Next, we will be hearing from Mauna Kea and Nainaho.
Aloha. Can you hear me? Sorry. Maybe I have to bring it closer to me. Sorry. Excuse me. I think that'll work. Aloha. Mahalo for this opportunity to present before you. I just take a minute for myself as we aloha kia kuana. Okay, Kealoha Pisciotta. Kealoha Pisciotta for Mauna Kea and Nainaho, and for myself. I'm a cultural practitioner. I just need a moment speak about the sacred Mauna. Ikia kuana, kuana o makua. We welcome you to abide with us this day and bring blessings upon all in this room and all of those of goodwill and aloha of the world. And we thank you for this honor to stand. We ask for the blessings for your greatness and purpose. Aloha. The purpose of a contested case hearing is so that petitioners like us, practitioners and people of the general public with an interest that is unique to the Mauna, be it being a hunter, a recreational user, a practitioner, can come forward and make sure that we can present our case for this board so that you can make an informed decision. And to present how that decision will impact us. And how that decision impacts us is because, and the general public is important because our rights are protected by the Constitution and other law. It's also a way to make sure that the public doesn't have to carry the burdens of going into litigation, for example. Anyways, the Supreme Court remanded us back to this place, and this hearing constitutes a huge endeavor of, almost a year in legal proceedings, 6 months in 44 days of hearings. I think over about 5 months. 70-something witnesses, thousands of pages of documentations, and so on and so forth. So we were remanded back by the Supreme Court, but not because we did anything wrong, but because the board failed to give us due process and put the cart before the horse. So we were not given that fair opportunity to be, fully heard and in a meaningful way heard. Yes. So, but unfortunately, this hearing didn't fix that. The reason why it didn't is because the hearing officer, for all intents and purposes, just didn't do that consideration. She cut and pasted, basically, the university's and TIO's, TMT's positions. And what the problem with that is that it violates the law under 92-12, where each position, according to the university, there are over 5,000 findings of fact and conclusions of law combined. So she needed to actually look at those and make a ruling on those individually. I mean, I'm not saying that she, if they were all related to one issue, I'm sure she could have combined them all. But she needs to respond to them, because without responding to them, it takes away our right to ask for a motion for reconsideration. We don't even know what the problem is. And more importantly, it gives you an incorrect idea of what this hearing was actually about, because you don't see the facts involved. She took into consideration virtually nothing from any of our stuff. And I don't know how that's possible. I mean, for Mauna Kea and Nainaho, we've gone through three contested case hearings, I think 4 actually, over a 20-year period, and we've won in both federal and state court. And we've been even the Supreme Court ruled on our behalf. So I cannot see, it's not possible for the hearing officer not to take into account any of our arguments or our positions or anything like that. So we just take exception to that, and we have to accept and object to her findings in whole until we recommend maybe that you remand her back to do it. I mean, the taxpayers paid hundreds of thousands of dollars for her to do that job. So, anyways. There's two important things that I want to talk about, and one of them is the responsibilities of this board from the perspective of Kapa'akai. BLNR, you're the only agency who's able to protect and enforce our rights, Native Hawaiian rights. No other agency can do that. What's happened here is we've been caught up in a jurisdictional confusion between the university and BLNR, and each one not knowing what the other is supposed to do or allowed to do. What's brought that this jurisdictional confusion also has resulted in BLNR you delegating your authority, and Kapa'akai specifically barred that because BLNR and BLNR alone can delegate our regulate and enforce our rights. So only you can do that. So it's been delegated in many ways. It's been delegated to the University of Manoa, then to the University of Hilo, then to Office of Mauna Kea Management, then Kahukumauna. Now, none of those agencies are allowed to regulate or enforce our rights. Only BLNR can. So Kapa'akai specifically said that you must do three things. You have to identify the rights and resources of Native Hawaiians. You have to assess the impact to those. And then you have to implement protections for those. Now, that can't be done because the university did it for you. You have to do it. Because the university obviously is going to select on behalf of what they're the proponents of the development. That's why you folks must do it. Okay, and the other thing about Mauna Kea that is very, very important is that it's our water source. And the public trust doctrine not only protects our rights, but also our resources such as our water. So it holds, that the state, when having to balance the two, between a use and a protection, right, that you have to go on the presumption and in favor of public use and access and enjoyment. So your job first is not to protect a development, but protect the resource against development. And to balance that, to balance that, what it also means is under the public trust doctrine, the public's use always is superior to the private use. It doesn't mean the private use can't be done, but under the public trust doctrine, you have to go with the presumption and in favor of the protection. Also, in determining this, you have the precautionary principle. The precautionary principle, in short, is saying that if you, in the absence of conclusive evidence to the contrary, you must side with the protection. And so it's not our right also to prove that the impact will occur. It's the proponent's right who's seeking to take that resource to prove that it won't. It's the despoiler's obligation to protect and to prove that what they want to do will not affect our rights. It's not our job. That was also very important here, is the unlawful shifting of the burden of proof. It is not our burden of proof. It is the opposition's, but the hearing officer unilaterally shifted the burden onto us. We're not the criminal here. Okay? And so I believe the court remanded us back. They specifically warned against cutting and pasting. They had said that it demonstrated that the board did not do their due diligence in consideration. They specifically stated that, sorry, I don't think I can find it right here, but they specifically warned against that, is what I really want to say. And it's in our exceptions. We stand on our exceptions at this point, and I did reserve time for rebuttal. And I would like to just say that we really take exception to the hearing officer's failure to take into account the evidence presented. I mean, it's thousands of documents. These are not only our documents, they're their documents. They're the university and TIO's document. So they admit these things. It's not our burden. You know, we're just there to say, hey, they can't meet the 8 criteria, and here's why. And it is our position that they can't meet not only some of the criteria, but they cannot meet any of it. Thank you.
Thank you. Next up.